We are here with Colorado's best attorney, Phil Harding from Harding & Associates in studio this morning. Thanks for joining us, Phil, in this segment. You and I were talking about this. This kind of stuff really interests me, how to pick juries. So critical.
Yeah, so all my friends, because I'm an attorney, come up and they say, give me the insider tips on how not to be picked. And I give them insider tips on why they should be picked. And I've got to tell you, I haven't heard from any jurors that haven't said they've loved their experience, except for one. We were talking about that one.
Yes.
There was a jury, and hopefully we can get into it, that just absolutely hated me.
So when you go through this process, you're seating jurors, you actually have a very specific way of doing this.
I do, and you know, on choosing them, I actually have number cards, but I want to go into really what jurors don't know to educate everyone out there that's going to be potentially a juror.
And this is such an important thing, what they don't know.
And you will never know this. And number one is the parties have tried to settle the case, and if you ever want to throw out rules of evidence, that's Rule 408. There probably is insurance, but if you mention insurance during a trial, it is a mistrial, and whoever caused that has to pay for the cost to retry. It's crazy. The judge has excluded evidence, and then if the defense ever says, and they get up at the opening argument and said, ladies and gentlemen of the jury, we've accepted liability, watch out, because now it's excluded how let's talk about a car accident, how the car accident took place.
We don't get to know.
You would not get to know, and let me tell you why. It's called a 402-403 objection, and first of all, 402 says all relevant evidence is admissible. That sounds right, right? 403 says, although it may be relevant, if it's unduly prejudicial to one party or the other, it will be excluded. So if the defense gets up and says, hey, we've accepted liability, all of a sudden, if the guy was drunk that caused this accident, it's not relevant that he was drunk, only how far someone's injured. Now, if someone was drunk, wouldn't you give more money? Yep. Right, I would. You know, if the defense is, and that's called punitive damages, rarely are those awarded. But when you're a juror, you are not thrown to the wolves. You get these jury instructions. And let's look at just one of these jury instructions. And here it is. And there are like 30 of these things. And it says, any finding of fact must be based upon probabilities, not possibilities. You should not speculate about a fact. Now, here's the big one. You must not be influenced by sympathy, biased, or prejudiced for or against any party. So that's why if they brought in that someone was drunk, you would have prejudice towards them. And so if someone is injured, it's only relevant as to how much they've been injured.
That's fascinating to me. I mean, so this is just one of the instructions.
Right, and let's get into that one case that you and I were talking about.
Exactly.
So it was a bike-on-bike case, right? And whatever... If you call a witness, like if I call a witness, I'm responsible for them. I'm responsible for what they say. And so I called the other side, right? There were two bikes going. They went out into my guy. The first one went back in, and he's an attorney. He's a defense attorney. And so I called him out of order. So now I'm responsible for him. And I said, look, you're a criminal attorney. I'm a civil attorney. I've got to tell you, Rule 411, you cannot mention insurance, and if you do, it's a mistrial, right? We were talking about this. And so I get up there, and before this, I'm winning the case. The jury loves me. They're looking at me. And so then defense gets up, calls him, and they're like, so you have anything else to say? And he goes, well, that's about it, except for what Mr. Harding said I can't talk about. All of a sudden, the jurors are writing down, because you as a juror can write down questions, and it's going to the judge.
And they're not going to look at you.
That's right. And it's like, what did Mr. Harding say? What did Mr. Harding say? I went to the judge. I'm like, Judge, you have to give an instruction that says there are rules of evidence that we can't violate. Judge says, nope, not saying anything. So this jury made no eye contact. We ended up winning the case. Jurors walk out, and normally I like talking to them. They want to know about evidence, and they wouldn't even make eye contact. They bolted. But I prevented a mistrial. They just didn't know that.
I had no idea there were so many stipulations and things that went into this. That's fascinating, Phil.
Yeah.
Thanks for sharing that personal story of yours. So to reach Harding & Associates directly, call them at 303-762-9500. You can get a free consultation anytime. And you can find Phil online at hlaw.com. Thanks again for sponsoring the segment.
Thank you.